if you're branding a new product, branding a company, or rebranding, here's two common mistakes that we see clients make that could easily be avoided if you just spend a little bit of time on it. So when it comes to branding, two of the biggest mistakes from a trademark perspective that we see are failing to conduct a trademark search and choosing a name that's just too descriptive. So when we come to trademark search, a lot of times clients will say, I bought the domain name or I registered the business, and they feel like that somehow cleared them to be able to use this as their brand. But that's not enough. Trademark law doesn't necessarily care if you registered the domain name, doesn't care if you registered the business name, because there's no check there to make sure that you're not infringing on someone else's trademark, especially in the US when you're registering a business name, whether it's an LLC or S Corp. Most states only look at what prior companies are registered with them, and so long as it's not an exact match, they will register it. But likelihood of confusion is much more complex than that. And here is the Trademark Manual Examining of Procedure that talks about likelihood of confusion. I'll put a link in the bottom of the video if you really want to get into it, but it really lists out, a lot of different factors, the relatedness of the goods. Goods and services need not be identical. Something we see a lot is food and beverage versus restaurants. They pretty much treat them almost as the same. And then looking at the similarity of the marks. And that's what we're talking a lot about here is the similarity of the marks, because sometimes clients just don't even do that when they're picking a name. So one way that they make a big mistake is by thinking that by spelling a name slightly different or taking a word and turning it into two words, or vice versa, taking two words and putting it in one word, will somehow get them around a prior registered trademark. And that is not enough. And I'm going to look at the next slide where we go a little more into deep depth on that. But one thing that we should consider is when we're looking at it is, so something like here, and I'll show you an example of different spellings, but phonetically equivalent, is people say out loud the brand that they're looking for or searching. So they might not know the exact spelling. So spelling is not enough to differentiate you from a competitor, especially if your goods or services are close. And here's some of these are from real cases. Some of them are just ones I made up, but, express versus express with an X, site versus site, real versus real, bear versus bear, two versus two, throne versus throne, cyclone versus cyclone, or might be pronounced cyclone also, Cresco versus Cresco, Seikos versus Seiko, and Exceed versus Exceed. Some of those are from cases where they held that they were too similar. I believe all the capital ones are from actual true cases. The other ones were just some that I made up as examples. But when you're doing a search, if you search for just express, so this is the U.S. Patent and Trademark Office where you can search to see if there's a similar mark. One of the things we always do is recommend to clients when they're thinking about rebranding, before they even hire us to do our clearance search, is to use the USPTO to see what else is out there. And if they're thinking of using something like Express for a retail convenience store, you know that it's an issue here. But what you see here is that these are all expressed with an EX. So you have to think in your head, well, how else could it be spelled? And then do that search as well. And you'll see that it's a completely different set of results when you look at Express with just an X at the beginning. So this software, the search software that we use to clear, that many other lawyers use, where we pay for it, not the free search tool at the USPTO, most cases will automatically help us do the search, but when you're doing the free searches, you need to think in your head, how else could this be spelled to do that? So that's a really key point there, is the spelling and making sure that you're not infringing that way. Again, you need to look at the overall commercial impression of a mark. So sometimes words that are not exactly the same, or not even spelled slightly different, but maybe have the same meaning, could be an issue. Sometimes they don't. It depends upon what other competitors are out there using. And also, you need to look at the goods and services. If they're related in any way, like I said, I showed you, I think, on here, where there's a whole section about restaurants and food beverages, where in most of the, while likelihood of confusion often found where similar marks are used in connection with both food or beverages and restaurants, there is no per se rule. They say there's no per se rule, but in most cases they have been finding that, thus the relatedness of such goods and services may not be assumed, and the evidence of record must show something more than the similar or even identical marks used for food products and restaurants. In most cases, what I've seen is they're going to hold that if you're filing for a beer and there's a bar or restaurant with that name, they're probably going to reject it, or potentially vice versa. There was one case that they see it here where Coors actually overcame that, but that's one of the few cases. And then the next biggest issue that I see is descriptive trademarks. Branding, marketing people love to use a descriptive name for a product so that people know exactly what it is when they see it. That being said, it means that it's a much weaker trademark to begin with. You can't even get on what's called the principal register right away with a descriptive trademark. I like to use the example of Staples. When Staples first opened, they sold staples and other office supplies. That is descriptive. Similarly, Chipotle, they sold food that contained Chipotle in it. However, over time and over building up a brand, investing heavily in your branding, you could potentially overcome that and acquire distinctiveness. But what happens with descriptive trademarks is you see a lot of people in similar industries use them. So they become very weak, meaning that's a very crowded space. It's harder to differentiate all the different people using the same mark for the same thing. So what is a descriptive mark? To be refused registration on the principle under 2E1, which is merely descriptive, a mark must be merely descriptive or deceptively misdescriptive. So also if you're saying that it's a computer and it's not a computer, that's deceptively misdescriptive. A mark is considered merely descriptive, describes an ingredient, quality, characteristic, function, feature, purpose, or use of the specified goods or services. And here is an example: apple pie held merely descriptive of potpourri, most likely because it had the smell of apple pie. Bed and breakfast registry held merely descriptive for lodging services. Male pap test held merely descriptive of clinical, pathological, immuno testing services for detecting and monitoring prostate cancer. So these are just some examples of things that they consider descriptive. That means they cannot get the full protection of a trademark. And here I'll put this link in also. There's a lot more there. But generally, stay away from descriptive wording as much as possible. It's okay to maybe have a non-descriptive word with a descriptive word. If you think of Lenovo computers, the word computer is descriptive. It's telling you what the product is, but Lenovo is the brand, or Samsung tablets, whatever it is. Those things are okay, and what you'd have to do anyway is disclaim that part of the trademark so that other people can use the word computer, laptop, tablet, whatever it is that you're doing. So I hope, just to sum it up, remember, do a search before choosing a name. Make sure that, it's clear from a trademark perspective, not just that you can get the domain, that you can register it as a business, but that as a trademark, you're not infringing on anyone else's rights. And ensure that you're not using something too descriptive that is just going to be easily rejected or be weaker to start, or there's going to be a lot of other people in your field using that name or something similar. Please, if you like this, click the like button, subscribe. Feel free to put any comments in and we'll respond to them, or always feel free to reach out to us. Thanks for watching and have a great day.